Number 15 and 16. Counsel, would you like any rebuttal time?
1 minute, Your Honor, please.
1 minute, sure, go ahead.
Matthew Hellman on behalf of Appellant Goldman. I'd like to begin with accomplice liability and then turn to enterprise corruption. The trial court repeatedly instructed the jury that it could convict without finding intent. Eliminating an element of an offense is one of the most fundamental errors that there could be, and it was especially prejudicial here because intent was the critical issue in the case, and the evidence of intent concerning Dr. Goldman was so thin. Now, there's no real dispute that the trial court did eliminate the element of intent in its instruction.
But don't we have to look at the whole jury charge?
We do have to look at the whole jury charge.
It's one word.
Well, it's
against many other paragraphs and pages that make it clear that the word does not mean what the court said.
Well, several points in response to that, Your Honor. First, when we're trying to figure out was the jury likely to be confused, normally we try to figure out theoretically might it have been confusing. In this case, of course, we know the jury was confused because when it received this instruction, it asked the judge, explain accomplice liability, please. At which point, after defense counsel tendered a correct instruction, the court repeated the error and, in fact, doubled down on it because it did it twice. First, it said to convict, you can find either intent or a bad act. And then it said the last words it gave to the jury in the charge on this point were, to acquit, you must find both no intent and no bad act.
Nobody objected.
There were objections, Your Honor, actually.
I thought you had Goldman. I didn't think there was any objection by Goldman.
Well, we joined Keschner's objection on these points, Your Honor.
Yeah, I read Keschner's. I'm not sure you did preserve it. If you didn't preserve it, then you're into Turner and those cases.
Well, we can talk about preservation, but I want to make a couple points clear because I think the nature of the error actually speaks to the prejudice inquiry that we might want to look at in a case like this. The rule in New York is, under People v. Kelly, is that when a jury is given two inconsistent sets of instructions, one correct, one incorrect, we don't assume that the jury figured out what the right statement of the law was. We assume they used the wrong one. And in People v. Martinez, the court looked to Kelly and held that a harmless error analysis is inappropriate when inconsistent instructions are given. So this isn't a harmless error case at all. Under Martinez and under cases that have applied it, like Kim's, the rule in New York is when an inconsistent instruction is given, you assume the jury did not follow or was not able to divine the correct statement of law, and reversal is required.
Doesn't the whole thing, though, turn on whether we think as Judge Rivera said, that the instruction read as a whole conveys the idea that you need intent and knowledge both, or we don't? I mean, doesn't it boil down to our reading of that and our decision as to whether or not as a whole it does or doesn't?
That is the question. And under cases like Kelly, where there was Kelly was a case in which the insanity defense was at issue, and the judge said, much like this case, said that insanity was available or available only if the defendant could show or the state could show that he didn't understand the nature and of his acts and knew they were wrong, and really it should have been an or standard. So it was an and/or question, and the dissent in that case pointed out that the judge had actually used the right formulation other places in the charge, and that was not enough in the Kelly case, and I submit it's not enough here. And it's particularly, that has to be the right outcome in a case like this, where the jury expresses confusion on the very instruction that is at issue, and then the court repeats, not just once, but twice, the problematic statement. As Judge Cardozo said, the force of an and versus an or is hard to avoid, and this is, that he was talking about a probate case. Here we're talking about whether someone is convicted or not.
Why don't you get to the criminal enterprise issue, counsel?
I'd be happy to. I'd be happy to. Separate and apart from the accomplice liability point, there's also an enterprise liability question in this case. The court below departed from what other courts, really every other court who have looked at the question directly, has said on this subject. The enterprise corruption statute imposes super added penalties. It punishes a defendant more than just for what the underlying offenses are. And when should those super added penalties come into play? Well, we know from the statute that it requires not just criminal acts, but a criminal enterprise with a continuity of existence, structure, and criminal purpose beyond the scope of individual.
Why doesn't this case fit that definition?
This case doesn't fit this definition because There is no continuous structure here or continuing structure here. As Justice Snyder said in the Army case.
We had doctors, we had runners, we had billing people, we had a pretty good organization going, not only once but more than once. And why is that not a criminal enterprise?
Because it
and are you saying that all an organization like this has to do to exempt itself from criminal enterprise liability is to put one guy at the top and have him or her control the whole thing?
No, I wouldn't put it that way. The reason this isn't a continuing enterprise is because this case did come all down to Vinarski. Whatever.
Yeah, and why isn't Vinarski the key to the continuity here? Why isn't he?
Well, as Justice Snyder.
With all the different pieces that are continually moving here.
Well, Justice Snyder found it logical, and we submit that it is, that you really can't say something's continuing if it depends just on one person, that's not a continuous structure.
I thought the appellate division addressed it, and I think they were paraphrasing the statute. They talked about individual incidents, not individual participants. If I understand correctly, you would have the rule be that the people have to prove beyond a reasonable doubt that the absence of one person would not eliminate this criminal enterprise. That's what they would be required to prove under what you're suggesting.
To obtain the heightened penalties beyond that which are, of course, available for the underlying conduct. It does say criminal incidents, Your Honor, but if you're talking about continuity beyond criminal incidents, the logical inference from that is that even if you get rid of defendants A and B, this thing is still going to go on. That is the bad thing that this statute is.
So why isn't it possible if he's gone, someone steps up that criminal corporate ladder, if you will?
Well, that's a question of proof, and in this case, there's nothing on the other side. The people had their chance to suggest that was the case, or prove it, really, and there's nothing on the other side. Vinarski is it. He's the alpha
These two guys
and the
are
omega.
Functionaries? The other two are functionaries?
Well, of course, Dr. Goldman wasn't involved in this at all as our submission, but Vinarski, without Vinarski, the whole thing falls.
Well, his name is on the clinic, right? And he's the
He was an
doctor
owner, of
who
course.
sees patients, yeah?
He did see patients, but
So he's got some important, significant role in this, no?
Well, not in the illegal aspect, of course, Your Honor. The point here is that Dr. Goldman, of course, was an owner of the clinic, but what Vinarski said was never talked to him about illegal things, never gave him a kickback. When we used the stamp to submit for fraudulent supplies and goods, it was in the back room away from him. This was the people's witness with his liberty and his daughter's liberty on the line who did not implicate
Okay,
Goldman.
Carlos, let's hear from your colleague, and you'll have your rebuttal time.
Good afternoon, Your Honor. Susan Salomon for Dr. Keschner. First, I would also like to reserve 90 seconds, please, for rebuttal.
You have it. Go ahead.
Thank you.
You're challenging us, but go ahead. We can handle it.
First, with respect, I would like to take issue with the count of errors here in the accomplice liability instruction. Whether you can turn to or not, I will just refer to the appendix at 2275 to 76. But I'll just put it this way. The court gave instructions that were 50% okay and 50% not okay. The not okays were never identified as such. They never were corrected as such. Let me just note for you the not okays. The not okays started the whole charge to begin. And then it says, but only if the evidence shows that the defendant you are considering had knowledge of the crime and intentionally aided or assisted the others who are not on trial. We call this accomplice liability. That's not right. As you know, it's not right because every single crime with which my client and Dr. Goldman was charged required specific intent, not mere knowledge. We then get down to the third or fourth paragraph where we have, or he is not guilty because he had no knowledge, no intent, and did not intentionally engage in any conduct. So there we have everything that the defendant has to disprove. He's got to disprove everything, including lack of knowledge. And it's obviously burden shifting. Then we end with, and this is in the supplemental charge, again, to be guilty, it must be proved that he knew, intended for it, or intentionally engaged in some conduct. So there the jury's given a choice. Pick one. Yes, it's interspersed with correct iterations, but again, this Court's jurisprudence makes clear that when you've got a jury that's given right and wrong, and here we don't have just one misstep, we've got 50% missteps.
What bothers me is when when you look at those statements taken out of the entire charge, they're troublesome, and we're looking at them, and we're looking at them on the written page, and we're looking at them after the fact. Here, it doesn't appear that anybody, well, certainly the lawyers or anybody, the judge, caught those ands and ors when they were spoken, and so do we get to question whether there's any likelihood that the jury did?
Well, the jury asked for re-instruction, and as we know, the Court, if you're asking, do we have to have some knowledge that the jury picked the right one or the wrong one, I would say no. And in fact, I know Judge Rivera's opinion in Kim's was the most recent one, I think, to invoke, I think, the Martinez and Griffin doctrine. In other words, when you've got instructions that are correct and incorrect, and you have evidence that is sufficient to convict on the incorrect legal theory, that in itself obviates, that constitutes harm. In other words, we can't, when a jury, we don't know which one the jury picked. Obviously, here, the jury had, a half, 50-50.
Going
we don't
to
know.
the next step of what our analysis has to be, what if we find that this alleged error, well, not alleged, that this error was not preserved?
Okay.
And so then we have to look at whether it was ineffective assistance not to object.
Correct.
And then do we look at the parsing out these little words and whether, and here, arguably, again, it would be a Turner error. Does this fit within Turner error?
Yes, it does, Your Honor. This Court's cases have made clear that the charge and jury requests for information can be, I'll just put it this way, can be the ballgame, that they can matter. They can actually direct what the verdict is going to be.
The district attorney points out a number of areas in the charge that are perfectly fine, and that I guess the argument is kind of wash over these minor changes.
As I said, I think we've articulated 50-50, half okay, half not okay, the not okay never withdrawn. We also, by the way, have a judge who at sentencing used knowledge, which again is not correct. Now, on the Turner question, I think this Court has said that the error really has to, if you'll just, the error here was so egregious and decisive that it overshadowed and tainted the representation. We acknowledge, or I acknowledge, because I did make a full-throated and effectiveness argument here, that counsel, yes, this was a complicated case. There were a lot of submissions, but counsel is tasked with paying attention at what is arguably the most critical juncture of a case. This Court has found an attorney ineffective for not objecting during summation.
Does that mean every time we find that there's a problem with the instruction, it's a Turner error per se?
Not every time that there is a problem, Your Honor, but every time I would say that here, when you have instructions that, by the way, were hammered home to the jury as the most critical thing in this case from the get-go, from voir dire, when the prosecution voir dired on accessorial liability, through the judges saying these are special instructions, breaking them out specially, when everybody is talking about it, when the DA in summation is talking about it. I would say counsel should never stop paying attention during a trial. And I know that it's hard.
This is the instruction on the
on accessorial liability.
to the jury note, correct?
I'm sorry, Your Honor?
I'm sorry. This is an instruction responding to the jury's note?
Yes, but yes.
So there's no Orama claim here.
No.
So the defense counsel had an opportunity to look at this and know what was going on before the court spoke.
And he had two chances to get it right.
I'm looking at one that, he's either guilty because he had knowledge of the crime, intended that it be committed, and did something intentionally direct or assist in its commission. That seems pretty clear to me.
Well, as I said, Your Honor, I agree that that half of them are okay, but the ones...
I know, but you keep saying, well, let's forget those half.
Well, no, I'm not saying forget those halves. I'm saying that they fold into this Court's Kelly jurisprudence and Harrison, which is when you have half that are right, half that are wrong, and ands and ors do matter, conjunctions matter. Statutes are written with a reason.
I know, but I mean...
But how is a jury
The
supposed...
thing is, you have a strong argument on the conjunctions. Obviously, you have a logical argument, but the problem is I think you're arguing to us that this would be a mode of proceedings error and that we always have to consider. That's the only way we get to this. It wasn't properly preserved. So.
No, I'm not arguing mode of proceedings either. I'm saying I will take on the ineffective assistance of counsel burden here, but I do believe that we meet it. This Court looks to the fairness of the proceedings as a whole, and when you've got accessorial liability that has been trumpeted as the major issue in the case, and when counsel has two chances to look at something, he's either got to know preservation law, or else it should be just dispensed with,
counsel.
or pay attention.
Okay.
Thank you.
You'll have your rebuttal. Counsel.
Good afternoon. Good afternoon, Your Honors. My name is Susan Axelrod. I represent the people in this matter.
What with the criminal enterprise? Let's hear about that.
The short answer is the statute just doesn't have anywhere in its plain language the gloss that the defense is trying to put on it. The statute says you have to prove continuity of existence beyond the scope of criminal incidents. That's all it says. In this particular case, we had an organization that committed thousands, I believe it was thousands, of these various insurance frauds. It was a structured organization. It lasted for a number of years. It didn't fold up with one.
What about the Vinosky issue? They say that it's
but again, you have
no organization beyond him.
Well, I don't think they're saying there's no organization beyond him. They're saying if he left the organization, it would not continue to exist. And the first answer to that is, again, that's not what the statute requires. The statute just says, given what's in front of us, was there a continuity of existence beyond the scope of the criminal incidents, not given what might be happening in 2 weeks. So they're
saying while they participated, you have this criminal enterprise.
Exactly. And
the fact that it might not exist tomorrow if Vinosky is no longer part of it is irrelevant to the analysis?
The statute doesn't require us to prove what might have happened if a particular person left. It only requires us to prove that what is in front of us is an organization that has a continuity of existence beyond the scope of the criminal incidents. The idea being we don't want to punish ad hoc, let's get together for a moment, commit a robbery, and all go our separate way. We want to punish the sophisticated organization that comes together and works and commits a number of crimes in a structured environment. Whether or not
continuity of existence is what has happened up until this point, not what may or may not happen in the future.
That's exactly right. Otherwise, we'd have to be proving an unknown. There's no reason,
Well, if Vinosky had left or he decided I'm out of this business and they closed shop, you're prosecuted for what had happened in the past, assuming you get within the time frame.
If the organization decided we don't want to continue anymore,
we've ended. We're not making the kind of money we want to.
They still were a criminal organization with a continuity at the time that they existed, with a continuity of existence beyond the scope of the criminal incidents. So, whether Vinosky left or not, what you look at is what they were doing from 2006 or 2002, 2006. I get the dates a little bit mixed up.
You're flipping it and saying with Vinosky, it is a criminal enterprise, whether or not what might happen later if he wasn't there.
That's correct. And because the Court is asking me facts, although I don't actually think that we were required to prove them, I just want to point out that, in fact, Vinosky held no special skills. He'd been a bookkeeper in another organization. He saw how it was done. He came over and did it here. There's no reason to think one of the bookkeepers here couldn't have run that same organization. He didn't have the licenses like the doctors that made him unique. So this idea that this type of organization couldn't exist without Vinosky, I mean, that's what they would like you to conclude that as a factual matter. Our argument is one, you shouldn't even be looking that way. But if you're going to go to the facts, there's no reason to draw the inferences that they're asking you to draw. The bottom line is we had a structured, sophisticated organization. The point of the Enterprise Corruption Statute is to get at those structured, sophisticated organizations. We use the appropriate statute. We prove the appropriate things. We didn't prove something that the statute doesn't ask us to prove, and we offered sufficient evidence to sustain the conviction.
Is this a Turner error? Was the instruction a Turner error?
It's not a Turner error, but, you know, if I could, Your Honor, I would like to turn the Court's focus just a little bit. And as Ms. Solomon is saying, she only gets your consideration on this if you're willing to review an ineffective assistance claim. There has not been a 440-10 in this case. The defense has just thrown up their hands and said, you know what, not preserved, must be ineffective. Now we get to argue what the error is.
Isn't it apparent from the face of the record? Why would it have to be 440?
Well, it's not completely apparent from the face of the record. For instance, as we argued in our brief, that second mistake in the supplemental instruction with the or rather than the and, it's our position that that was a mistake. So it would be efficacious to allow the defense attorney to get up there and say, you know what, I didn't hear it that way either. I heard it correctly.
Error.
Exactly. The other thing is,
aren't you saying that if that was an error that would get you a new trial, and I'm sitting there as defense counsel, I'm going to say, let that go. Let that go. Why would I say that?
But then you have to say that. I mean, the defense, then that's a strategy, and our argument would be that that's not ineffectiveness, that's cleverness.
Maybe quite effective, counsel.
Exactly. The other thing is, these are not the only ineffective assistance claims that they're raising in this brief. Mr. Goldman is raising the failure to object to the enterprise corruption as an ineffectiveness. Mr. Keschner is, raising the failure to object to some of the opening statements as ineffective. They're making a general ineffectiveness claim.
And not a Turner claim, you think?
Well, exactly. They're trying to make a Turner claim within the one, but they've actually raised a number, and they're asking this Court just to waive away preservation by just making this all ineffectiveness without doing the thing that this Court has said that they should be doing, which is doing a 440-10 and allowing the defense to explain what was on their mind at the time, and also allowing the trial judge to look and determine whether or not, in fact, there's a prejudice prong here, because that also happens at the trial level. So, while I don't believe there's a Turner error, I don't think this Court should be looking at any of this, because I don't believe that the defendants took the steps necessary to raise these claims properly before this Court.
But what do you say about the Court's error itself in the charge? Forgetting about the preservation issues and whether we get in that, because if you're arguing Turner, then you seem to be conceding that these were at least arguably egregious errors.
Well, we conceded that there were errors made. We would not at all concede that they're egregious. Under this Court's jurisprudence in People, especially in People v. Umali, you look at the charge as a whole. And throughout the charge, the Court stressed that the people had to prove intent. The Court read the accomplice liability statute. And now I just lost my train of thought.
All right.
The Court, and the ironic thing is, in terms of stressing the knowledge, that's because they asked for it. They actually got up and said, look, we want to make sure that the jury understands it's not just mere presence.
I thought this was a supplemental instruction in response to a jury note. Have I missed something?
There's two. There's first the main charge, which is
main charge, yes, I know.
And that's where that first and mistake comes.
First mistake.
Then there's the supplemental charge where the judge repeats the main charge with its first and mistake.
Yeah.
But then when she's circling back to what would fix it all by reminding the jury that, in fact, the people have to prove all three prongs, that's when the transcript indicates that she used the or. And again, it's our argument that that's, in fact, a transcript error. So there are two ands that shouldn't be there. But when you look at the entire charge as a whole, it was clear to the jury that the burden was always on the people. She started by saying the burden was on the people. She said the people had to prove every single element beyond a reasonable doubt. When she charged the elements of the crimes, which she reminded the jury that we had to prove beyond a reasonable doubt, she said, if you find that they acted either alone or in concert, you must find that they had the intent to commit the crime, et cetera, each time stressing that we had the burden of proof. In terms of the jury being confused, juries often ask for recharges on statutes or elements. They were hearing a lot of testimony. It was a long trial. They'd been charged on Thursday. They had spent all day Friday asking for various readbacks. By the end of the day, they were now turning to the statutes. It made sense to say, well, can we hear this again? I mean, this wasn't a confused jury that kept coming back and going, you know, we don't understand. I mean, on the one hand, you said the people have to prove all three things to convict. But on the other hand, now you're telling us the defense has to prove all three things to acquit, and we can't figure out where the middle ground is. There was none of that. The jury asked once to hear the accomplice liability charge. They then went back and deliberated. They asked for further instruction on other charges.
So they're going through the stages.
They're going through the stages. They're looking at the statute. They're doing what a good jury should do. And hearing repeatedly that the burden of proof is on the people have to prove intent, the people have to prove accomplice liability. Well, there were those really two unfortunate ands and potentially that one unfortunate or. It did not leave the jury confused as to what their duties and responsibilities were. My time is not up, but unless there are any questions, I'm happy to ask the Court.
Thanks, Counsel.
I'll just ask the Court to affirm. Thank you.
Appreciate it. Counsel rebuttal.
Thank you, Your Honor. I think from the people's recitation, the one thing everybody agrees on is that this charge was riddled with error. I think we're having a hard time cataloging just how many there were. And it's easily 50%, as my colleague points out.
I'm kind of surprised at that. You say it's riddled and you can't count them all?
Yes, Your Honor. We have one in the main charge, two afterwards, and there's a suggestion that maybe it was a typographical error to explain the last one.
That's three.
That's three. That's 3 times the jury was told the wrong thing.
You said riddled and you can't count them all. That's the reason I asked.
I apologize for the hyperbole. There were 3 misstatements that eliminated the intent element of the offense in this case. The question now is that error warrant reversal? Under Martinez and under Kelly, you don't even do a harmless error analysis in that context. It simply requires reversal. The question now is, if there was not preservation, I'm happy to talk about preservation because this is not a case in which defense counsel sat silent while this charge went on.
You're addressing the point I brought up. Was it a strategy?
Yeah, correct. If that was a strategy, it was not carried out well because what counsel said after providing a correct charge to the court, what counsel said after providing a correct charge was that the court's charge removed the burden from the prosecution of proving each element. And then, when the court went ahead and gave it anyway, counsel got back up and said, you're not getting the mental culpability for larceny in the charge. I should get the exact language here. Accessorial liability is divided. I've heard it, said the judge. You've already told me this, right? Cut off counsel. So that's what's going on here. Now, if that wasn't effective, that was not effective to alert the court to the error, that has to be ineffective assistance of counsel. What possible tactical judgment could there be to allow your client to have the intent element omitted from the charge? This case was not about whether Dr. Goldman worked at the clinic, whether or not he acted at the clinic. This case was about his intent. I've already recounted the paucity of the State's evidence on intent.
Okay, counsel. Thanks.
So therefore, we'd ask that at a minimum this be reversed under ineffective assistance. Thank you.
Counsel rebuttal.
Until today, I know that my adversary noted the absence of a 440, but never articulated any conceivable trial strategy because there is none. Counsel did make a protest. It was wrong. Counsel said this charge is burden shifting, but didn't say what. It said places the burden on my client, but what? This Court's jurisprudence is clear. If a judge grants a request to charge, he put in voluminous request to charge. He was intensely interested in this, but he basically blew it when it mattered most. The judge said, I'm going to grant your charge. When a judge grants a charge, it is then incumbent on counsel, when the charge is given, if it doesn't hew to that request, to say, whoa, this was a charge request you granted, but this is completely wrong. This is not what I wanted. But that did not happen here. So there is no conceivable trial strategy here. And yes, Your Honor, I do submit it's 50-50 here. Again, I will go through it, but I beg you to go through the reply brief, which really does set it all out. There are only a few paragraphs of this charge. And it's and half of them have the thing wrong. And it's not just ands or ors. It's getting rid of the specific intent element, which is the entire ball game here. Everybody said, pay attention to the charge. It doesn't matter that the charges with respect to the individual crimes articulated the intent. Again, the judge said, this is a special instruction. Pay particular attention to this. These are special charges about accessorial liability. That's what mattered here. If I might, if I still have a few seconds.
You do. Go ahead.
Okay. On the OCA question, we have argued that it really we believe that our gloss on the statute, which is basically sort of added on to what counsel argued in his motion to dismiss here is that our legislature doesn't have criminal enterprises of one, unlike the RICO statute. You just can't have a one-person enterprise. And basically, that's what this thing became. Vinarsky's own testimony and all the debriefing, he had, I think, 100 debriefings by the prosecution before he testified in this case. With pride, he said, no one knows anything but me. No one's coming after me. He asked about someone who was, oh, isn't he close enough to be your son? He said, no, my son died. Nobody was taking. He held these things, I can't pronounce what he calls them, some Russian name for these special sticks that had all the information on them. No one else had to do anything. Yes, there were doctors, but we're talking about what made this thing a criminal enterprise, and only he did, and the people's proof made that out. And our legislature obviously has recognized that a one-person enterprise doesn't pose the danger that enterprises with more than one person do. And he didn't just run it. Only he had everything.
What about the people's argument, though, that it exists at the time, you're looking at it at the time that it exists. So even if he's a central figure, it's at the time that it exists, you've got that continuity.
No, but at the time, again, we argued that our interpretation of the statute also allows for an examination of the human beings and not just incidents. I think it doesn't do violence to the statute. This Court's other cases like Kircharla or Western Express looked at it from a structure point of view. Yes, this thing had a structure, but you're allowed, I believe, to look at the human beings. And when you have only basically one human being who knows how to do everything, only he's got all the knowledge of how to make it the corrupt enterprise, not just the enterprise. No, he's not a medical doctor. So even within the finite amount of time that he ran it, it was just his crime. And now
you can't function without the other people.
Exactly.
Without the other expertise.
Yes, but he is the sine qua non. And so we would say the people are not bereft of things to try to go after.
Saying he's irreplaceable?
I'm sorry?
You're saying he's irreplaceable?
Yes, he made himself irreplaceable. He declared himself so.
Thank all of you. Appreciate it.